Can you hear me pretty good out there? Great. Amazing technology. Welcome to the Planning and Land Use Management Committee. It's Tuesday, December 2nd. I'm joined by the Honorable Council Members Jose Huizar and Jack Weiss. Hope everyone had some beginnings of the happy holidays and nice day of Thanksgiving, and more to come after a good solid few weeks of work. So hang on to your hat. We have several items today that we'd like to cover. Just a few points to consider as you come up to the microphone. One is, please give us your name and address before you speak. Keep your eye on that clock. We have 2 minutes. I know some of you have taken the time to write some very eloquent letters, and sometimes you run out of time before you get to the punch, the main point of your letter. So be cognizant of the 2 minutes and selective as to how you want to address your letters to us. If we are covering an item where someone has already mentioned or pointed out your concerns, it's okay to say that very simply. I agree with the previous speaker, and give us anything new you might want to add. And that way we can move a little bit quicker. Today's committee has several items, and there are a few that are special given the cards that have been submitted. But there are others that we can move on. But before we do that, we do have a guest with us, an appointee by the mayor, Mr. Javier C. Angulo, to the East Los Angeles Area Planning Commission. That will be the term ending June 30th, 2011. And I'd like to ask Mr. Angulo, if you'd like to come up to the microphone. I want to welcome you, sir. I'm making the trip out to City Hall. And more importantly, offering us your services as a volunteer, as a commissioner. So you want to just give us again your name, your address, and just start off with what's motivating you to be part of this commission.
Sure. It's Javier Angulo. I reside at 2663 Sitchell Street, Los Angeles, 90031, in the community of Lincoln Heights. I'm interested in serving in the commission because I've been very cognizant in terms of the changes that have been going on in the Northeast community. Now that we have an excellent opportunity with the goal line traversing all across the Northeast, I think there's some great opportunities to develop along the goal line and create some very sustainable developments along that corridor. So in addition to that is the green space and having a balance between the need for housing and also a need for parks and other spaces where people can, live healthy lifestyles and also have fun with their families and friends.
Well, I appreciate the fact that when you're very familiar with the infrastructure in the Northeast, the opportunities that are there. Northeast also has one of the largest overlays when it comes to the preservation of our historic housing stock. And so we're always trying our best to protect our neighborhoods that are R1 in nature and have these historic characteristics. But there are also opportunities given just how historic these neighborhoods are. These are the first suburbs of the city. I like to call it the original suburbs of the city. And therein lies much opportunity, I believe, in how we can be creative in addressing the pressures caused by the density, the challenges we have with the rise in poverty levels, but at the same time, the great relationships we have with amazing institutions. At USC's General Hospital and the medical centers, one of the highest employers of the region. We have some great thoroughfares that are, I think, prime for new vision. We have a riverfront district we want to build along the Los Angeles River, and having an individual like yourself, I think, will take us a long way. Can you give us a little bit of more background for the sake of this committee in terms of your experience with land use and or real estate?
Sure. I can tell you my my experience with dealing with the community, I served as a National Director for Civic Engagement for the Naleo Educational Fund, which is a national nonprofit organization. So I have dealt with issues of sustainable development, issues regarding safety, land use, in that regards, in terms of the public interest. In addition to that, I've also, through my parents and through my family, we also have several property that we manage and we also develop outside of the city of Los Angeles, mostly consisting in the city of Whittier. And my responsibilities in that is to manage the day-to-day operations. So I think it gives me a unique perspective in managing tenant and landlord issues. And I'm very keen on how to balance those two issues and bring a resolution.
Great. Well, it's good to have someone from Lincoln Heights involved at this level of the city, and more importantly, who understands the trials and tribulations of many of the neighborhoods surrounding downtown. So again, appreciate your work, and I'd like to open up any questions to my colleagues.
Well, welcome, Mr. Angula, and thank you for your willingness to serve. I think you'll be a great addition to this commission, and I've known you in several different capacities. Where are you employed currently?
Well, I currently ended my employment as the Deputy Political Director for the No on Prop 8 campaign.
Oh, okay.
So right now I'm just doing independent political consulting.
Oh, good. Great. Well, thank you for your work on that as well. So I look forward to working with you. The East Area Planning Commission covers all of CD14, I think, and so certainly my staff and looks forward to working with you as well. There's a lot of interesting new issues developing in the area, and someone like yourself coming from those communities, knowing those communities, committed to community involvement, certainly with your background in development issues and working for Maldif and Naleo, brings a type of perspective that I think could be appreciated by the local residents. So thank you.
Thank you.
I gotta get used to that button. Mr. Angula, I'd like to recommend that you become one of the newest additions of the APC for East Los Angeles, and we have an aye vote for that. Yes, it's unanimous. So that will be the recommendation of this committee. We look forward to seeing you in council. We'll try to make it painless. We just have to make sure you fill out the forms for the ethics by that day. So with that, again, thank you for taking the time, and look forward to working with you.
Thank you, Council Member.
Have a great day.
Thank you.
Okay. So that takes care of item number 1, and let's just run through the agenda.
When is that coming to council? Do we know yet?
Barbara, are we scheduled Mr. Angula for what day?
His item is scheduled, or his confirmation hearing is scheduled in council on the 10th of December. Yes.
December 10th.
Yes.
So we see Mr. Angula December 10th. That being said, let's just run through the agenda, and we'll identify those items that are special and those that we can take an action on at this time. So items 2, 3A, B, and C are all special, given cards have been submitted. Item number 4, we can continue to December 9th. Number 5, we can continue to mid-January.
I have the date of January 13th on that one.
January 13th.
Correct.
Okay, so Barbara has warned us, January 13th. Okay, then our item number 6, seeing no cards, we can put this on the consent calendar. Item 7, we can continue to December 9th. Number 8 and 9, we can also put on the consent calendar. 11, we see no cards, and we can put...
Before you go on to speak on 11, Andrew Westhoff, representing Councilmember Wesson, just submitted amendments to number 11. They're on the desk.
So we'll call that special?
Actually, if you want to just review
Let's move on
approve it
to
with
the
the
amendments.
amendments, it's right there on top.
So we can move with approval, given the amendments.
Yes.
This is for 1044 St. Andrews Place?
Correct.
Okay. And let's see, what else here?
Councilman, I think you skipped number 10.
Number 10?
Yeah.
Let's see, we have cards on number 10?
I do not believe we have cards on number 10. We have 12, cards on 12, and I think 2 and 3.
But not on number 10, because I
Not
haven't
on
marked
number
down.
10.
Okay, so we can move that on consent as well. 11, we do have cards, correct? Yeah, we do have cards there. 12A and B, special, 13 special, and 14 will continue for 1 week. So, council members, if we can move on item number 11 with amendments and all the other consent items. Have a second on that?
Second?
Okay, that'll be the action of this committee. And let's go to our planning director for her report. Thank you so much for joining us today.
Thank you very much, and I just have a few things I wanted to share with you today. I am hoping that you heard this through other sources, but if not, on November 17th, the State Department of Housing and Community Development approved the city's housing element. I want to share with you that it's very unusual. Typically, the State Department sends back the housing elements with changes that they want to see, and I was surprised and thrilled to see that they approved it totally. And this is very good news for us because this allows us to begin to submit applications for Prop 1C money and other state and infrastructure money that we would not be able to apply for if we did not have an approved housing element. So this opens some financial doors for us, and we are very thrilled. We worked hard with the State Department to hopefully meet all of their needs before we turned it in, and we were successful in doing that. So I wanted to share that with you. I wanted to also share with you that much of the work that the Planning Department, or at least the management, has been working on over the past couple of weeks have been budget-related issues that impact our budget in the Planning Department this year. As you know, we are all trying to save money and to contribute back to the general fund to help make up for the revenue deficiencies. And while we have, I think, contributed greatly, I do want to share with you that we are still moving forward with new hirings and promotions. The Planning Department currently has 90 vacancies, and I think that is really important to know. 90 vacancies. We have received recently permission to fill 65 of those vacancies, but I need to share with you that many of those vacancies will be internal promotions that are necessitated by our civil service rules. So we still will have to go back to actually backfill the vacancies that are created by those promotions to work our way down to the new capacity, which we can only get at the bottom of the rung at the assistant planner level. So I wanted to share with you that we have promoted 6 new senior planners, and we're working on backfilling those. We just recently promoted 2 new ZAs. We hired from outside or other departments 3 new commission executive assistants, and this is big for our area planning commissions. And we are currently working on promoting 18 new city planners, so that's our focus. We're going to work very hard and aggressively to bring in the new capacity that we need. We won't be able to fill every vacancy, but we absolutely have to continue with the hiring in order for us to complete our work program. And then finally, I wanted to share with you that we are continuing to take our message on the road. And so in the past couple of weeks, one of our staff folks, Claire Bowen, represented the City Planning Department on a panel at the Greenbuild International Conference last week in Boston, where we talked a lot about the city's plans. And to tell you the truth, we're doing really, really well compared to other cities in terms of our new requirements. I also spent 3 days 2 weeks ago at Harvard meeting with the planning directors of the 30 largest cities in the country. We talked a lot about what we are doing around sustainability. I talked a lot about our river plan, but we also talked a lot about the new monies that could potentially be available through the new administration for infrastructure, and the role that we as planning directors through Harvard, the Lincoln Institute, the American Planning Association, the role that we could play to help promote investment in cities, in urban areas, in infrastructure that supports smart growth, and in infrastructure in cities, and I continue to tell everybody, cities that are coming to the table with their own money that can help leverage the federal resources, and I think Los Angeles is well positioned. So we all continue to tell the LA story at the federal level in the hopes of getting some of those federal monies back to our city.
Great job, our Director of Planning, Gail Goldberg. I want to congratulate the department on their diligence with the housing element. That's a very critical piece. As the competition becomes more stiff at the statewide for these housing funds, it's going to be, we're going to need every advantage we need to be able to compete along with the whole process of dealing with our park space, park dollar monies that are coming down the pipeline. So they're all connected, very important. And we want to congratulate too the staff, both building and safety and planning department, in working with Councilmember Perry and the work they did today regarding how we deal with these nuisance properties and how we actually can have a real vehicle that will help us shut down these properties that are so punitive to our quality of life, especially for the children and the families living in some of the toughest neighborhoods in the city. And that, I think, was very important, and it shows a different spirit from the planning department, building and safety, housing, and the city attorney, and that's the teamwork that we need. So kudos to the department and building and safety for their hard work.
Thank you.
Anything else from the colleagues? Okay, well, yes.
Well, Ms. Goldberg, about a week ago in Budget Committee, there was a proposal by the CAO's office in seeking to cut $55 million out of $100 million that we need to cut in this year's budget. A proposal to make some cuts in the planning department on positions. There was some discussion about whether we should keep some of those positions because of the need to continue to provide the EIR section sufficient staffing to expedite those. I talked about community plans and the need, we wouldn't want to affect the progress we made in getting more community plans online to be reviewed. But there was no one in the room at the time who could talk to what were the priorities or what would be effective if we make those cuts. Has that been brought to your attention?
Yes, and the reality is that the money that was taken from our first 6 months of this year's budget were salary savings based on the fact that we had these 90 vacancies that we had not been able to fill. The only change that was important for us, because we can still go forward with our hiring program as long as there's no hiring freeze, we could give back that money and still move forward, with the single exception of the $100,000 that we had asked to be reserved in the planning department's budget from salary savings to contract, to allow us to use some contractors to help us with our EIRs where we are far behind and we are struggling to get the staff in there. And at the vote of the Budget and Finance Committee, that actually happened, and we are moving forward. As I pointed out, or as was pointed out, this is not even a loss of the $100,000 because the EIR is fully cost recoverable. This is just give us the upfront money to hire the contractor, we'll give you the money back. And so that was done, and so it will not, the money that was taken will not affect our hiring program. The 65 positions we're continuing to move forward
neither
with.
Would it affect the community plans and the staff
No,
needs
the
for the community
community plans right now do not have the full component. They are supposed to each have 2 full-time planners. Right now, they only have 1. And that full-time planner is not only working on the community plan, but also working on cases. So part of the hiring is to give them the additional resources so that we can do this at the pace that we promised.
Thank you.
And I know that there's a lot of expectations of how these committee plans can address some of the
Right.
more difficult issues that the city faces, so we look forward to seeing those implemented.
Thank you.
So thank you, Director Goldberg, and thank you for coming and giving us that update. And let's move on to our next committee item. Roberto, item number 2.
Yes, Councilman, it's a motion signed Reyes instructing planning, building and safety, and the city attorney to make revisions to the sign ordinance and to create time, place, and manner restrictions.
I think what we failed to do is improve the microphone on that podium, so you still might have to speak into the microphone. But
Can you hear me?
There you go. Yes.
Okay. Good afternoon, members of the committee. My name is Alan Bell, Planning Department staff. The subject motion, which was co-presented by council members Weiss and Garcetti, was referred to staff on September 7th. Today, I will present a verbal report on this motion and related matters. Since this motion was referred to staff, the Planning Department and the City Planning Commission have been moving in a number of different directions to craft a unified strategy to update and to strengthen the city's sign code. Specifically, there are currently 5 different ordinances, all related to signs, that are currently in play. So what I'd like to do over the next few minutes is to outline the status of each of those different legislative initiatives, and then discuss the work program that specifically relates to this motion, because as part of that work program is how we intend to knit together all of these different ordinances that are now in play and come up with a new strategy labeled Time, Place, and Manner to update the city's sign code. So first, let me go over all the ordinances that are currently in play and that will be coming shortly before the City Council.
And you will give us the Reader's Digest version of each one, right?
Yes.
Okay, good.
All of these relate to sign. They're all different facets of the same strategy.
Okay.
So, sign districts. Right now we have in our zoning code a baseline citywide sign ordinance, and then there is a provision within the zoning code that allows the establishment of special sign districts. And within these sign districts, different regulations are allowed, and they can be tailored to the specific needs of a particular area. So it's a 2-tier system, a baseline sign ordinance, and then the possibility of establishing sign districts that differ from the baseline regulations. On September 11th, the Planning Commission approved revisions to the enabling ordinance authorizing establishment of the sign districts. And the Planning Commission's action speaks directly to the second half of the Weiss-Garcetti motion, which is the establishment of clear criteria related to land use designations for sign districts. The Planning Commission's thinking is that we need to have very clear criteria as to why certain areas should be allowed to have differential sign regulations as opposed to the rest of the city. And the Planning Commission's action focused on establishing criteria that would relate to the historic, the cultural, or the entertainment character of a district. In other words, there would need to be something related to the historic character of an area, or the entertainment character of an area, or the cultural character of an area, as to why this area should have regulations that differ from the citywide baseline regulations. So this commission, the Planning Commission, adopted this ordinance, and we did transmit that particular ordinance to the Planning Commission for action. The second ordinance that I want to discuss about is regulations on the A and R zones. Again, earlier this year, on March 22nd, the Planning Commission approved an ordinance to remove any content-based restrictions on signs allowed within the A and the R zones. The Planning Committee, this committee, approved this ordinance in May, and since that time, it has been under review and development both by planning staff and the city attorney staff. Again, what is important about this ordinance is trying to institute within the A and R zones, agricultural and the residential zones, time, place, and manner restrictions, and to take out any kind of content-based restrictions on signs. The third piece of this that is currently in play, it relates to fine art murals. In the year 2000, when the council adopted a ban on new billboards, on new supergraphic signs, the council also adopted a ban on new mural signs. The reason why was because the council felt that we could not make a content-based distinction in terms of fine art murals and any other type of mural that would be available to a commercial advertiser. The Planning Department prepared a report which we released in September of this year outlining a different strategy to enable, through establishment of art easements, using a methodology that was trailblazed in Portland, Oregon, that would allow private property owners to donate art easements to the city. This would make, in effect, these fine art murals public property, part of the city's collection of fine art, and so therefore we would regulate these not as part of the sign code, but we would enable them as part of the city's promotion of public art. And we have prepared this report. There is going to be a joint hearing before the Planning Committee and the Arts Committee to consider this. The reason why I mention this again is because it's very important as part of our overall strategy to have a time, place, and manner-based sign code. If we take fine art murals out of the sign code and regulate them out of this different model, again, that was trailblazed in Portland, then we advance that particular strategy. The final piece is the Planning Commission initiated and did adopt in November an interim control ordinance to ban new off-site signs or billboards, new supergraphic signs, and to also ban alterations to existing billboards. This particular ICO would be for a 6-month period with the possibility of extensions up to a 15-month period. The reason why the Planning Commission adopted this particular ICO and also why the City Attorney's Office is strongly recommending the adoption of an ICO on the same topic is because of the amount of litigation that is currently in play that calls into question the legal basis for the city's current citywide ban. So I think the take-home message, certainly from the City Attorney's Office and certainly from the City Planning Commission, is that action is needed in case this ban is overturned in the courts. We need to have a different set of regulations, a different model for regulating these types of signs. And so I would like to now discuss the work program that is going to come up with this new model. It is going to enable us to shift the way in which we regulate signs as part of a new model for our particular sign ordinance. To begin, to ensure that the city's sign code does not violate the First Amendment, and that's the reason why we have to take all of these particular actions, every proposed sign regulation really has to pass a two-part test. And the first one is, does the regulation favor one speaker over another? Does the regulation favor one message over another? If the regulation does either or both, then it is not content neutral. So when we review all of our sign regulations, we have to screen them in terms of this particular two-part test. What this means is that the city's sign code may only regulate the time, place, or manner in which signs are displayed or created. But that still provides the basis for developing a set of powerful tools for mitigating the impact of signage on the city's visual environment. So I think what the public is saying, I think what the City Planning Commission is saying, we need a sign code that mitigates the impact of signage on the visual environment so that when you look at any particular site, it is not dominated or overwhelmed by the signage on that particular site. So based on this principle of regulating signs based solely on the time, place, or manner in which they are displayed or created, the code's current definitions of off-site signs and supergraphic signs are really unnecessary. In the new sign code, we should therefore consider eliminating the distinction between on-site signs and off-site signs, or designing supergraphic signs differently from other types of signage. If we do that, then we pave the way for regulating signage in the following ways. The total amount of sign area that would be allowed on a lot, for example, in relation to the lot street frontage. Again, does it really matter what the content is of the sign? What is most important from a public standpoint, from the standpoint of protecting the visual environment, is the total amount of signage and how it is arrayed and displayed on a particular site. The content really is irrelevant in terms of the impact on the visual environment. We can also regulate sign illumination, whether it is allowed or not allowed, and at what times of the day illumination would be allowed. We could regulate the level of intensity. We could regulate the height of signs. We could regulate the absolute height of signs, or we could regulate the height of signs in relationship to the proposed height of a building or the height that is established within a particular height district. We could regulate the structures that support signs and their locations on a lot. For example, while it may be very reasonable to prohibit all pole signs, all off-site signs, all billboards are in fact pole signs. Does it really matter whether it is a pole sign that is displaying an off-site message or an on-site message? The impact on the visual environment is exactly the same. So the issue is, let us regulate the impacts, not the content. Roof signs, again, the same principle. Do we want to regulate roof signs because of its impact on the visual environment? The issue is not the content of the roof signs, but its impact on the surrounding neighborhood. The regulations would also address certain types of signs. Our sign code is currently silent on the issue of digital signs, whether they should be allowed or not allowed. It may be appropriate to regulate the placement and the orientation of digital signs, their illumination and their brightness, message duration, and transition. Many cities that have already taken a look at how to regulate digital signs regulate the number of seconds that a particular message can stay up, and then it must transition to another. So this is something that we'd want to investigate in terms of applicability to the city of Los Angeles. With under the heading of time regulations, it may be appropriate within a 24-hour period to regulate when digital signs can be lighted and at what level of intensity, and when they cannot, in relationship to their impacts on residential neighborhoods. So those are some of the types of regulations that we can implement within the framework of a time, place, and manner regulation, and would be the focus of our study over the next 6 to 8 months in terms of crafting this new particular sign code. The methodology that we would take is to research what has been done in other cities that have taken the lead in terms of addressing these types of regulations. We would conduct a one-day workshop where we'd invite experts in the field to help staff craft these types of regulations. We would also try to engage some of the traffic safety experts working with the Department of Transportation, digital signs, flashing signs. The research shows that these do in fact have an impact on driver attention and must be considered in crafting the final regulations. Finally, the environmental impacts would also be considered during the course of this particular study. We understand, given the number and the type of lawsuits that have been filed against the city, that it is important to act quickly. That is why it is important that we have an ICO, and this particular ICO is going to be presented before the Planning Committee next week. This is an outline in terms of a focused, somewhat aggressive work program to come up with a new set of sign code regulations. Our goal is to get this to the Planning Commission within 6 to 8 months so that we have a new paradigm for regulating signs, and we get this before the Council and the decision makers as quickly as possible. I think it's a doable work program. It is aggressive, but I think there's something that the Planning Department we can handle, and we can come up with a good new regulation. So that concludes my presentation. If there are any questions, or
I do have a question.
I can answer them.
Well, first, thank you for that breakdown. I think it's important that the city family begins to look at this issue from a bird's eye view, and let's look at all the pieces that are out there and start bringing in some semblance of a direction as to how we can move together. And I want to thank the city attorney's office and your office in Building and Safety for allowing for this dialogue to occur publicly to the extent possible, given all the legal issues that we have. But just more importantly, that we have my colleagues engaged in this discussion in a way in which we understand its impacts. And as we go through these deliberations, I'm hoping the deputies of respective offices are taking the message back to their council members. But there's one point, and it's a small issue given what your statements. You made reference to when you look at a location or a site, and a judgment has to be made as to there's too many signs or the nature of the signs. Are you speaking to a building? Are you speaking to a street? Are you speaking to a corridor? Or are you just being very general in the context?
I think it could address all of those.
It could.
Absolutely. I mean, I think that when we're looking at our commercial corridors, our C-zone corridors or sites that have M zoning, we need to take a look at what are appropriate levels of signage, not the content of those signs, but appropriate levels of signage. Really, we're trying to regulate, we're trying to balance two things. One, the right of the public to have a visual environment that is attractive, to protect the brand of the city of Los Angeles, to reduce visual clutter, because there are a lot of different important reasons for doing that. At the same time, businesses have a need to advertise. They can't survive economically unless they can advertise. So we're balancing both of those, obviously, two very important objectives.
And my question refers not to the content, but to the nature of the structures and the presentation of the information. So when I drive down Robertson Boulevard in the west side, you get one impression of the number of billboards and signage that's out there. When I go down Figueroa Street in northeast Los Angeles or Highland Park, there's a different impression given the quality and the type of structures where these signs are being mounted and how they're being placed on a building. And yet if I go down Soto Street or if I go down Wabash, it's a whole different feel as to how these signs are being treated and the quality and, again, not the content.
Right.
So these are the types of issues that you will be addressing.
Absolutely. And I think it gets to the types of signs and the number of those signs and the total sign area. So monument signs create a different impact than a pole sign. A roof sign as opposed to wall signs. I mean, those are the tools that we have to work with to try to regulate, trying to get our objective, which is to mitigate the impact on the visual environment, recognizing there are different types of signs. The total sign area, that's one measure, but the placement of signs on a particular site, should they all be on the wall? Should we allow signs to be planted within the required yard? All those are really kind of urban design considerations. What we're trying to do with our sign code is define the envelope within which everyone is going to have to play.
Okay.
And once we establish those ground rules, then the advertisers, the public, the property owners, they can put whatever type of signage is they deem appropriate or desirable, but it has to fit within that particular set of restrictions, that particular envelope.
Gotcha. Okay. Thank you. Thank you for that presentation. Colleagues, any questions?
Thank you, Mr. Chair. I want to thank you, Mr. Bell, because I thought that was an excellent presentation, and this is a subject which engenders so much controversy, and it gets bumper stickered so much, and yet it is so complicated, and your presentation made clear just how complicated an issue it is, and even though you're not a lawyer, I thought it was a terrific presentation about the legal issues involved, and I hope that people listening and the people who are not here but who follow the issue pay attention to what you said, because it shows just how complex this issue is, and I appreciate the careful manner in which you explained everything. Now, I introduced this motion because I believe that because of the lawsuits and for other reasons, frankly, because it simply can be done, it is important and it's good public policy for the city to revise its sign codes. And you have outlined the way, generically, that I want us to proceed, which is, you call it time, place, manner. I also call it time, place, manner, but it's really not quite that. It's more of it's content neutral, it's a public policy, planning policy, geographic based approach to signage. Because in some parts of town, signs are more appropriate than in other parts of town. By the way, colleagues, I should just tell you that you hear, or at least I hear an awful lot from people who are against all signs everywhere in the city. And I always tell them, you're focusing on the wrong, your focus is incorrect, because there are some parts of the city where signage is more appropriate than other parts of the city, and you may not live there, but you ought to respect that. Having said all that, Mr. Bell, my central concern is one of timing. What's the date of my motion? I don't have it in front of me. Do you know when I put the motion in?
Let me check.
The motion that I have on the record, just so that you'll know, council member, is dated July 29th of 2008.
Okay.
Yes.
Here's my concern. While what you explained today is comprehensive and complicated, it's not so complicated that those ordinances can't be drafted quickly. I really believe, and we have the agencies, different agencies present here, those ordinances can be drafted quickly and then given, I understand there's some public input process that you all contemplate. Why don't you tell us now, and it's not all on you because there's city attorney, there are other agencies, but why don't you give us now your estimate of the timeline for drafting of the ordinances and for going to the public?
Okay, certainly all of the ordinances that are currently have been either approved by the Planning Commission or by this particular committee, all of those can go forward certainly within the next couple of months. And I'm referring to the amendment to the enabling legislation to establish sign districts. That can go forward. I think that's a very critical piece of this. The regulations for agricultural and residential zones, that's a very important piece of that. We've been working very closely with council staff and with city attorney staff in terms of creating some revisions to that are necessary, but that will allow that to go forward. The most important one, with respect to your motion, we want to make sure that we do a good job, a credible job, that it's going to be an ordinance that is going to withstand legal challenge, and that it is going to take some time. I mean, as you know, sign codes are very complex, but we can make a commitment to get this to the City Planning Commission for their consideration from within 6 to 8 months from today. So I would say certainly by July of next year, I would hope that we'd be able to have that calendared for the City Planning Commission's consideration, and that would dovetail nicely with the timeline for the ICO, which has a 6-month period, and then possibility
let me
of
just say
extensions.
that I appreciate the first part of your statement about there are some that have made their way through the process that are going to get here sooner rather than later. I disagree with an approach that requires the council to wait 6 to 8 months for the substantive, for the money provisions, the ones that
Right.
affect billboards. It is not a 6 to 8 month job. I don't believe it's a 6 to 8 week job. I believe that while it is complicated, we have talented lawyers in the city attorney's office who, my understanding, and they work very closely with Ms. Trifoletti, are ready, willing, and able to go draft the darn thing. And I think we should draft the darn thing, and I ask the mayor's representative, I'd like the mayor to please weigh in with these departments and get it drafted. And here's why. I do not believe the ICO is the answer to everyone's prayers here. By the way, I don't know as I look around the city council that there are necessarily even 8 votes for an ICO. I don't know that. It may be the case, but my colleagues know you never know until it happens.
I think we have Brown Act issues here. Just kidding. Go ahead.
Anyway, I'm punchy today. So I think, and by the way, an ICO doesn't really do anything. An ICO just holds things in place until the substantive ordinance is passed. There are folks in this town who are more opposed to the ICO than to the substantive ordinance. So for all of those reasons, I don't agree with the 6 to 8 month approach. And And I would like to see the ordinance in Planning Commission in January. We're in December now. I'd like to see it in the Planning Commission in January. Do whatever public charrette or whatever those things are called that you got to do to get input from people, but get it done. So I do appreciate how hard you are working on it, and this is, I hope you don't take this personally. You have to stand there so I can say all this, but it's not about you. Please understand that. But 6 to 8 months is the wrong approach. This is not a death penalty case, okay? This is about signs. It can be done. My request of you and of all the other agencies is get it done now. In fact, if you get it done now, and you get it done as well as I think and know you can, the debate about the ICO will and should become irrelevant. It's an unnecessary debate if the substantive changes are made in the underlying code sections. So I don't know how we can, I mean, whether I make a motion to request that, Mr. Chair. You're the chair of the committee. I want to defer to you, and I do appreciate the city staff's efforts, and I don't want my comments in any way to be read as disrespecting the hard work they're engaged in. 6 to 8 months is not the right approach. This is very doable. It's very doable very quickly.
Why don't we do this? Because I plan to have consistent reports as we progress. And when we get closer to a point in which they feel they can give us a better perspective on timing, then we can push for those commitments.
Well, here's the thing. I mean, if you actually ask them, and I don't want to put them on the spot about this, what needs to be done, lawyers in my office, the lawyers in the city attorney's office, they know what to draft. It's not a secret. Okay. It can be drafted. I don't want to put the different agents. I don't want to create a situation where one agency is the bad guy, and right. I don't want to do that. But Ms. Trifoletti and I have known from the day we put the motion in how to redraft these ordinances, and I think it's wrong for the people of the city who have expressed a great deal of interest in this over the past several months to tell them that for no good legal reason they should wait for 6 to 8 months. So my request is that this be in the Planning Commission in January. I can do that as a motion, Mr. Chair, but I don't want to. I don't want to put anyone on the spot.
Again,
about that.
it's Mr. Bell. What have we said in 3 months? And we shoot for that without putting you on the spot.
Well, obviously, we're going to have to balance here. I mean, I appreciate the urgency of this, and I'll take this as a challenge to try and think outside the box and come up with an ordinance that we can do as quickly as possible. What I think we need to balance is if we know the answer to the important questions already, we have the best minds within the city.
Well, let's do this, Mr. Bell. Let's finish with item number 3, because we'll get more insight from building and safety, and let's weigh that out.
You know what? And why don't we? If we could maybe table the discussion for a moment because you have other items. I'll ask Ms. Trifoletti to speak with these representatives here and see if we can get a.
Why don't we do that? Because I want to get Mr. Bell off the hot seat, and also provide item 3 to be discussed. I think you'll get other perspectives as well in terms of mechanics, and you can have that sidebar, and we'll come back with item number 2. Okay, we do have 2 public comment cards with us today. We have, again, thank you for making the trip out to City Hall, Richard Spicer and David Garfinkel. Would you like to come on up, give us your name and address, please? You got 2 minutes. Just keep your eye on the clock when you come up to the microphone. Either gentleman can come first. Good afternoon, sir.
Thank you very much. My name is Richard Spicer, 4002 Holly Knoll Drive, Los Angeles 90027. Mr. Labange's district, right next door to Mr. Garcetti's district. And I'm here representing the action of the Greater Griffith Park Neighborhood Council. You have a community impact statement as part of your packet today, but I think it would be appropriate to read the brief sections that pertain to this item, and I'll save the others that pertain to item number 3 next, and that is this neighborhood council supports an interim moratorium ordinance on digital billboards, A. B, prompt removal of all billboards constructed or modified without permits, prompt notice to neighborhood councils of any ordinance regarding billboards or any request to install a digital billboard in their area, along with adequate time to study and comment. D, the City Planning Commission motion to study the safety hazards resulting from billboards. I hear quite a bit that's very much along the lines of which this board acted. The members would like to take the planning department's model in land use of communicating to the neighborhood councils when they have variances. That has been very useful to neighborhood councils to be constructive. In our organization, we have prepared for building and safety images of every billboard, 55 of them, plus other signs, with the street address, with the billboard company, and we have been working with the cooperative staff there to try and get them to use this at the beginning of their inventory. But the big concern is public notice and neighborhood involvement and getting a handle on the impacts. Thank you very much.
Mr. Spicer, thank you for your hard work and the due diligence you've exemplified with the level of work that you're demonstrating to us with those pictures and those images, and hopefully we can absorb all that information and
Thank you,
get to
Mr.
a
Chairman and
finish.
members of the committee and staff.
Okay, our next speaker, we have Mr. Garfinkel.
My name is David Garfinkel, 6073 Calvin Avenue in Tarzana.
Welcome,
I'm
sir.
president of the Tarzana Property Owners Association. I certainly agree with everything both that Councilman Weiss and that the last speaker said. Let me take a slightly different tact. There are ordinances on the book. 179416, January 2008, is a totally effective sign ordinance. We're prohibited by the agreement with enforcing that. We have specific plans that have sign ordinance material. We're told that the agreement with the various sign companies prohibits those enforcement of those provisions. It's nice that the City Planning Department is going ahead with some further tinkering around the edges. What's really required is enforcement of existing regulations, notice, inventory. We've also done an inventory in Tarzana, and there are 55 billboard faces, over 60 total off-site signs. The question really is, if you read today's LA Weekly interview with Scenic America's Kevin Fry, do we want to be known as the worst city in the country, to quote him, in terms of sign enforcement, or do we want to take the position that has been taken in 4 states in this country, in numerous cities, and in a city as business-oriented as Sao Paulo, Brazil, in limiting the effect of signs, the pollution of the environment, and the safety hazards of signs? So we support the moratorium, but more than that, we would like to see action behind the moratorium.
Well, thank you, sir. And in the following items, I believe you'll hear the level of work that has been occurring. I know sometimes when we see these billboards pop up and we wonder how did that happen, there's actually some work being done, and I want to make sure the departments are given the opportunity to share what it is they're going through and how they're approaching it, and we're going to be hearing that in the next few items. So we could, on number 2, we'll table that, and so we'll move on to item 3. We'll come back to item 2. Roberto, item 3, A and B and C.
Councilman, item 3A is a report from Building and Safety. It's a status report on modernization based on legal settlement agreements with Clear Channel, CBS, Regency, and Vista. It's in response to a motion Garcetti-Labange. 3B is a building and safety report relative to digital billboards at 1701 North Silver Lake Boulevard. This is in response to a motion Garcetti-Labange. 3C is a report again from Building and Safety. It's providing an overview of the status of off-site sign code enforcement, and it's in response to a verbal motion, Reyes-Rosenthal, adopted by the council on 10/22/08.
Okay. Welcome, sir. Give us your name and title.
Good afternoon. This is Hector Buitrago. I'm the chief of the Code Enforcement Bureau in the Department of Building and Safety. Would you like me to give you an overview of all of the motions, or do item by item?
Well, why don't you start with 3A and
3A,
let us know when you get to 3B and 3C, but I want to make sure each item is being addressed.
Okay. The motion on 3A is requesting a status of the number of credits and number of digital signs that have been issued pursuant to the settlement agreements. Let me just say that the settlement agreements provide for 420 credits for each CBS and Clear Channel and 38 credits for Regency.
Now, can you explain what is a credit?
Yes,
and how does that fit in your presentation?
The billboards companies can, on their own, decide how they want to use the credits. The credits can be used for modernizations. Modernizations are defined as digital signs, the tri-vision signs, which are the ones that can give you up to 3 messages that oscillate back and forth.
I hate to interrupt you again, but these credits came about because...
The credits came about in order to enable the sign companies to do a number of what is called modernizations.
And this is a settlement that the city council agreed to win.
That is correct. It was approved by council.
When did that happen?
There's actually 3 settlement agreements by Vista, Clear Channel, CBS, and Regency. So actually 4. They were approved between 2006 and 2007.
So these are very recent agreements that identified these credits, and you're going to describe how these credits are being used.
Right. And these documents were as a result of a lawsuit that were agreed upon by the city, including the city council and the mayor, and also approved by the courts.
Okay.
The settlement agreements for Clear Channel, for CBS, and for Regency provide for credits, which allows them to do certain number of modernizations. The modernizations can be a digital conversion, but it can also be what they call tri-vision, or they can also be used to legalize existing unpermitted signs. It is up to the sign companies to decide how they would use their credits. There is a total of 878 credits among the 3 companies, and currently we have issued 101 permits for digital conversions.
How many?
101. Most of them for Clear Channel. CBS has a few, Regency does not have any yet. Regency has submitted applications. There's a total of 51 pending applications for which the permits have not been issued. And Regency currently has 9, but not issued yet. Now, modernizations can also, credits can also be used to allow the addition of a second face. To a one-face sign, you can add a double face on the back. That's also worth 1 credit.
And again, I want to get back to the credits, because these credits came about because the companies agreed to take down so many signs.
In the settlement agreements, there is provisions for demolitions of signs. Clear Channel and CBS have agreed to demolish a total of 49 signs each, and Regency has agreed to remove 6 signs. And there is the time schedule is provided for in the settlement agreement for the removal of those signs.
Okay.
And they are the ones that decide which signs they're bringing down, not the city.
And you have a record of which signs have already been taken down?
I do have, we have provided a report specifying the locations of the actual addresses of the signs that have been removed.
Okay.
And actually, I have it here in my hands, but it's a report dated November 7th of 2008.
Okay.
It's part of the record.
All right.
So currently, there are 771 credits remaining that could be potentially all used towards digital conversions. That's per the legal settlement agreement.
Okay. Okay.
Oh.
Now, is that 3A?
Well, that's pretty much the status of the credits. I think I've tried and explain how they can be used and how many have been used, how many remain to be used, and it is, per the legal settlement agreement, it is up to the sign companies how they will use those credits. So they could choose to use the remaining 771 all for digitals or as they choose.
Did we give any type of like a sunset clause by which these credits can be used, or is it in perpetuity?
That is also, it is provided in the settlement agreement. Actually, indirectly is provided in the settlement agreement. The settlement agreement can last up to 6 years.
Okay.
It is really not stated so, but because of the fees that they agreed to pay, it's actually 6 years. But they can come in and apply. The agreement with them was that they would submit about 10, no more than 10 applications a month, so that we could actually handle the work. We didn't want to be flooded with hundreds of applications in one shot. So each company can submit 10 applications a month.
Okay.
And the settlement agreements, again, approved by everybody, also state what zoning regulations apply, and actually it is fairly clear that zoning does not apply. And we also provided a report November 21st where we're actually quoting the settlement agreements in which they state that we cannot deny a permit based on zoning regulations.
Okay. Any more harsh realities for us?
I think pertaining to item 3A, I believe I've answered the question, but if you have any questions, please let me know.
No, I don't, but you want to continue with 3B and C?
Okay. 3B is the status of the sign issued at 1701 Silver Lake. We provided a report that is dated November 17, 2008. I'm going to quickly run through what's stated on the report. The question is whether the issuance of that permit constitutes the proper use of a credit. Step number one, we had to make sure that the previously existing sign was legal, which we did. That was built pursuant to a permit from 1986, and we have a copy of the permit, and that permit is attached to the report that we submitted. Per the legal settlement agreement, Clear Channel submitted the plans on June 30, 2008 for a 12 by 25 digital sign conversion. We checked the plans. They're supposed to be plan checked by an engineer, which we did, plan check engineer from Building and Safety. We did that. And on August 3rd of 2008, the permit was issued after we approved the plans. We reviewed them in conformance with the legal settlement agreement, and the permit was issued on September 9 of 2008. On September 12, 2008, Clear Channel obtained the necessary electrical permit to upgrade the service panel. All that work was inspected by building and safety inspectors and was approved on September 16 of 2008. On September 22nd, we received a complaint about excessive lighting onto the adjoining residential properties. On October 10, the inspection staff from Building and Safety conducted a lighting inspection, and they found that the level of light at the property line of the residential properties, according to code, did not exceed the 2-foot candle level, which is permissible by code. So there was no violation in terms of the lighting emanated by the sign. So the sign was properly issued in accordance with the legal settlement agreement. There was no lighting violation, so we deemed that that was a proper use of a credit.
Could it be said that the standards by which this lighting was established were standards before these digital billboards were in existence?
Certainly.
So couldn't we as a city revisit that standard in light of what new technology is able to produce given the concentration of lighting in residential areas? When I say concentrated lighting on a billboard, I mean, these are different standards that I think we need to come to grips with, because I don't think anyone anticipated these huge, like almost like mini drive-ins. I mean, these are huge impressions are being made with all the color and the light in residential areas, and I don't think any one of us would have fathomed such an impact, given how sharp, how clear, and how bright it is. So could we, as policymakers, go back and readdress the standard of by which we allow these lights to actually perform?
I believe that we can, but let me say that the legal settlement agreements actually provide within the settlement agreement the lighting provisions.
I understand that. So that's, the more you share with me, the more I see we need to revisit the settlement agreement, but that's another issue. But go ahead.
We're using a standard that is not in the settlement agreement. It actually comes from other parts of the code that's more restrictive.
Okay.
So they meet both the settlement agreement as well as the other regulation of the code. But to answer your question, I believe that we, the city, can revisit that issue and come up with different sets of lighting regulations due to signage.
We just might do that. Okay, go ahead. You want to finish? Are you finished?
I'm essentially done.
Have
Yes,
a
any
question,
questions?
Yeah,
Okay, go ahead.
if I may?
Yes.
Thank you, Mr. Chair. I appreciate your presentation as well. My office has asked for several months now that the city take the following legal position with respect to these digital sign conversions, namely that the conversions, the proposed conversions, whether they are the result of a settlement agreement or otherwise, still need to comply with other California and city laws. And to this date, the planning department and the city attorney have not consistently and in a unified manner appeared at the hearings that my staff appears at, namely APC hearings, and stated that. So, for example, on December 9, there are a couple of hearings coming up that affect proposed digital conversions in CD5. It's my view that these proposed conversions must comply with CEQA, the California Environmental Quality Act, and that CEQA trumps any and all settlement agreements. It's my view that these conversions must comply with any other pre-existing local planning or zoning ordinance, specific plans, overlays, things like that. And finally, there is case law. There's case law. The Trancas decision, this decision coming out of the matter relating to the synagogue in CD4. There are cases out there about this. Now, why hasn't the city consistently taken the the position that I've asked be taken.
As part of item 3C, which is our having to reply to provide a status on all the outstanding motions for billboards, we talked with the city attorney, and we agreed that the city attorney would provide a report addressing that issue.
But can any, I just,
Do you want to just fold into 3C, so maybe we could answer his question succinctly? Are you done with 3B?
If you wish.
You want to just move into it?
I knew we were in, I didn't know what letter we were in. Okay.
Well, we're trying to follow the rhythm here.
Cool,
Jack. All right. Any questions on 3B? Let's jump into 3C then, and that way we can answer the question.
Okay. 3C is a motion for Building and Safety to provide a status report on all of the outstanding billboard motions. To that end, we compiled all of the motions that we believed were relevant, and we met with Councilman Reyes' staff as well as Council 14's staff to make sure that we were on the same of the same understanding. We compiled a table, and we provided the dates and a brief description of each motion, and we also provided the dates of reports that we had prepared and that was submitted in our report of November 18. Now, just to give you a quick summary, the issues, some of them, there was some overlap. The issues pertain to the question about credits, which I just talked about. The issue of the status of the off-site sign inspection program, which I'm happy to report that has been approved by Personnel Committee as well as Budget and Finance, and is going to full council this Friday. So once it's approved, the ordinance is effective, we're going to get started. So that's one something that I can give you a definite answer on. The other issues pertaining to all of the motions are issues pertaining to the number of permits issued and location, which I reported also in conjunction with 3A. The issue of zoning, the issue of permits for demolition. So actually, pretty much, I've already pretty much covered most of 3C. Now, let me just add to that, like I stated before, the city attorney has a few items for which they are the lead agency. One of them is the CEQA issue. Those other issues related to tougher penalties and fines, as well as status of certain lawsuits, and the city attorney will provide a report on that.
So in answering Councilor Weiss's question.
Yes. Now,
can you
the remaining issue, if I may, related to enforcement. There have been questions about the department not having any enforcement for signs, and that's not correct. Of course, we inspect every sign for which a permit is issued. That's number one. We inspect and approve when it's all done according to plans.
How many signs have you inspected?
85. Out of the 101 that have been issued, 85 have received final approval. So there's about 16 that still remain in some process of inspection. But enforcement in the city has typically been complaint-driven. And since 2002, we have addressed 7,800 complaints dealing with signs. This is signs in general, on-site as well as off-site.
So these 7,800 signs that you've dealt with,
yes,
are they still in place?
The proper action was taken. Either the situation was corrected or the sign was removed. You know, these cases also involve on-site signs. So some of them could have been banners or something that's easily taken care of.
Could you break down for us the end result of those 7,800 inspections? Is that something you can up into a computer and have a table that gives you a count? At least what I want to be able to say to our constituents is that we've been doing our job. There's 7,800 signs you visited. As a result of those 7,800 signs, X amount were taken down, X amount were improved or told to follow the law? I mean, do we have that kind of data?
We do not have that level of information. What we do have is the number of open cases, currently open, that are in some stage of enforcement.
Could you restructure your reporting format so that we know what the impact is of your hard work? Because you are spending time going out there. You are speaking to individuals. You are looking at signs, and you're responding to them. I'm trying to help you here in terms of how we define the results of our work. I think that would give us a better picture of what's being done. Because
we could do that from this point on, but the data that we have, which is historical data, just does not contain that level of detail.
Okay. Well, we'll talk about that some more, but...
Okay, me again.
This is
No?
Ray Chan, Executive Officer, Department of Building and Safety. In terms of the current open complaint cases, yes, we could put together a matrix to identify all the 293 complaints that came in that are still open in terms of the status of the enforcement in each separate stage, whether the case is still within the period of compliance or whether the case has been sent to the city attorneys for prosecution. Yes, we could provide that information.
Great. But we can't get that to the 7,800.
The 7,000, many of them would talk about very historical data. At that time, it's even before the computer. To dig all this information, it would take a huge amount of resource that right now we're focusing on to the OSPIT program, the offsite program, and also address all these motions and also to...
It sounds like a great public policy project for some great graduate school, but okay. All right. Go ahead. Councilor Weiss.
Want to get away?
Go ahead.
Maybe I shouldn't ask building and safety. I should ask city attorney and planning. I've said this so many times. My view is that any proposed digital billboard conversion must comply with California environmental law and pre-existing state planning and zoning rules and laws, and with California case law. I want the city to take that position and help block the proposed digital conversions that are going on every week in every neighborhood. Will you do that?
Jerry Birch, City Attorney's Office. We are providing a report to present to Plum on those very questions, Councilman. I believe it will be scheduled next week, certainly by the end of the year, and we would be happy to report to you on those issues then.
But I have a hearing in CD5 on December 9, which is a week from today, right? Week from today.
Yes, our next meeting's on
But
the
that's
9th.
but that's not.
It's on the
It's a separate planning. It's an APC. It's a building and safety hearing.
You mean during Plum Committee?
I don't. Things are going very quickly these days. I need
Councilman, we will provide our written report to you before December 9th.
Okay. And I look forward to that. But I just want to make it very clear that my office goes and testifies at each one of these things and states what I believe. It's not just that this is a preference of mine, it's law. State law is supreme to city laws and to subsequent city settlement agreements, and there's case law that I've read that makes clear that the city may not negotiate away by contract legal obligations that are imposed upon it through ordinance or statute. So I'm asking, but it's not me, it's the law. And I hope that is the position that the city takes in these hearings.
Well, Councilman, all I would say to that, again for the record, Jerry Burge, is of course there's the First Amendment, which trumps state law, and we are also reviewing the First Amendment.
So you believe that the First Amendment
said we are reviewing everything, and I just wanted to point out to you that includes the First Amendment.
How could the First Amendment trump the CEQA requirement for environmental review of a structure such as a deal? I mean, I must say, I've never heard that, but I look forward to your report.
Okay, so I think you get a sense of what we're looking for. And so I want to make sure credit is where credit is due when you do your work, but we need to help each other figure out, okay, how we are doing this and what it means. And we need to inform the community, the different stakeholders in the city, as to what is our current position and what we're trying to do to address these inconsistencies as perceived by folks who might not know all the intricacies of these agreements. And it's up to us as policymakers to either revisit these agreements, come up with stronger language, or take the necessary steps to reach our concerted efforts to improve the quality of life here in Los Angeles. So, is there any other point you want to make with either 3A, B, or C that you want to raise at this time?
Not pertaining to 3A, B, or C. I think I've provided the report and I've done my best in providing a report to you.
Okay, so walking away from this dialogue, I'm hoping that you could reassess the format by which you make your report so that we can understand what each visit means when you go out into the field. We have an inspector out there, and what is the end result of that effort. So we'll know if you visited site on X street that the result is not that it's going to come down, it has to be modified to fit what it was entitled to do. I think the other issue that I want to walk away from this dialogue is, and I'll ask my colleagues to join me on a motion that I'll introduce tomorrow, which is essentially revisit the notion of these light standards, given the impacts of these small drive-ins that they're having on our residential areas. I mean, these are really bright pictures and images. So maybe we just have to deal with the lighting issue in of itself. Might be mundane, but could also make a big difference. So again, it's just we're taking this one step at a time. So that being said, anything else from these items? Okay, so we'll note and file, in as much as a report is being submitted for informational purposes for 3A, B, and C, and we will continue this discussion as we move forward on our policies. Okay? We do have a card on item number 3, Richard Spicer.
Thank you very much, Mr. Chairman, members of the committee. The statement I wrote before pertains to these 3 items, but I'd just like to, perhaps why building and safety is still in the room, my understanding of the court cases is that CBS, Clear Channel, and Regency, and perhaps Vista, were supposed to identify in electric format all of their addresses. And after that, the inventory by building and safety could begin, and re-inspection of the signs and whether or not they are legal. We've just heard that inspection, because of funding and personnel, could start soon. So the question is, how soon is soon? And did those companies submit an electric format? I was at the building and safety this morning checking the database. It was a very good instruction from the staff there, but I couldn't identify any new submittals by these 3 companies in an electronic database format. What does exist is some information under the old format style, which calls out signs occasionally, but on one site, that call out was years old, and I was told by the staff, you have to look at every permit because they may not labeled as signs. So there are a few, just getting the information for the public who's concerned is difficult. Perhaps building and safety, if the committee were interested, could speak to those 3 questions. The sense of our discussion at the Neighborhood Council, which was extensive, it goes back to our recommendations on the Hollywood Community Plan with regards to billboards, is directly in line with what Councilman Weiss suggested, the applicability of these signs to CEQA, to existing state law, to case law, does seem to be something that ought to be explored and should be relevant. I will just repeat one other, it was mentioned in the Tarzana explanation that just hot off the web today is this review by the leader of the Scenic America to Los Angeles architects about how the case could be better in Los Angeles than it is now. And I would submit that for your interest if you would like to have it.
Sure, please submit it to Barbara. I appreciate that input. And that concludes items.
I'd like to conclude it. Thank you for the signs of leadership on this issue. They're greatly appreciated.
Thank you, sir. Again, thank you for taking the time. Okay, that concludes items 3A, B, and C. Is that right, Roberto?
Yes, sir.
So what's next?
I believe you wanted to go back to item 2 at some point.
Item number 2, so I saw some really heavy-duty sidebar action there. Does that mean that we come to terms with some kind of an agreement with Councilmember Weiss in terms of timing issues?
Yes, Councilmember Reyes and members of the Planning Committee. We're just discussing with our planning staff in terms of the potential of bringing something back to January for our City Planning Commission, something for them to be able to take action on. And there's a few things that we have to take a look at, and just making sure that we can do that is, the first thing is we'd be looking at a more generalized approach to the signed ordinance. I think that what was contemplated in the past is a little bit more comprehensive approach to updating the signed ordinance, but given that there's probably a handful of issues that are very critical right now to deal with all the issues that are before us regarding signs, I think that we can take a more focused approach now, and if need to in the future, we can come back and always augment that in the future. But if we can just highlight our most critical issues, so that would be one thing that we would do. The other part of it is we would have more of more strategic in our public outreach. I think that one of the things that our City Planning Commission wanted us to do as part of this was to look at bringing together blue ribbon panels and doing a pretty comprehensive outreach. Now, one of the things I explained to them when they brought that up is that would be inherently in conflict with trying to get this through expeditiously, and that we'd have to do something targeted.
Exactly.
And I think they ultimately understood that. So what we do is a very more targeted public outreach with the understanding that our system inherently has a lot of opportunities to have public comment. They will come before a City Planning Commission for a public hearing. They will come here to the Planning and Land Use Management Subcommittee.
That's exactly
so there's
right.
Plenty of opportunities there.
I mean, and the reality is that you see the folks are here today. There's even folks here today, an expert I see who comes and didn't even speak today, who knows from the architects, he knows how to weigh in. He knows how to send you an email. In fact, I'd like to ask, Mr. Wright, you could just send them an email tomorrow saying, here's from the AIA, here's what we want to see, because I just don't want this notion that we need to have some arbitrary amount of public outreach to just, irrationally elongate the process. We want I think you agree with me, we want this ordinance done, right? So let's get it done.
Right, and we have the. I think the players are very well known in terms of those that have been very involved in this issue. And I think we know who they are. I think the issues have been well publicized too. I think that even probably my neighbors down the street understand all the issues are because they've been reading in the newspapers. So I think we know the issues. I think we know the players. The couple things to keep in mind are that we would have to be looking at really doing a more generalized approach, and this committee would have to be comfortable with the generalized approach. I think that we'd understand there'd be more minimal targeted public outreach. We also have an issue in terms of the California Environmental Quality Act that we don't know the answer to that today, and I've had discussions with the city attorney's office, and they will need to see the ordinance first. So the one thing that is out of our control is the California Environmental Quality Act in terms of what is the appropriate approach to that. We'll want to make sure that we handle that appropriately. We also have, if we were to bring it to the City Planning Commission in January, the first meeting is January 8th downtown, and I don't think either way we'd be making the January 8th meeting, and understand that the City Planning Commission president, to a certain extent, has authority over the calendar of it. They'd have to be willing to agree to having the meeting in the second meeting in January in Browdy Center in the Valley. And then just the last thing is we'll as you heard from our planning director, we've got somewhere around 90 vacancies. So we will shift our workload to do it in our work priorities, just so that's understood too.
So let's target 3 months. It sounds like 3 months to me. December, January, February.
No, I think what he's saying, actually, is I asked them to get it done in January, and they're going to get the draft done in January, and I appreciate that. And then once the draft is done, I appreciate what you've said, which is that other clocks start ticking, and they can't tick now, they have to tick then. That's fine. That's fine. But what I want done is the draft of the ordinances. And you're saying you're going to get that done, and I really appreciate that.
That's great. Fantastic. It's done. The draft is done in January. All right. And we'll get all the wheels moving at the same time. Great. So that ends item number 2. We expect a report, a draft in January, and we'll go from there.
Just for clarity, I think they said the draft to the commission's office, to the commission, or is that to the committee?
City Planning Commission.
Okay.
City Planning Commission, but it's something that the staff at the council level can chew on as well, simultaneously, so that'll be good. All right, so that way we get more than one thing happening at one time. So that concludes item number 2. And we already did a public comment for that. So Roberto, where are we at now?
That would be item 12A and 12B, Councilman.
Okay, can we have the staff report on 12A and 12B? We do have some cards on this item.
Okay. Good afternoon, Councilman. My name is Frank Kwan. I was a hearing officer of the case.
Oh, Frank, you sound really good today. Wow.
Okay, they improved the microphone. Item 12A and 12B involve a Vaughn's Pavilions, new construction within an existing shopping center. The property is located on Ventura Boulevard between Oakdale and Corbin, so it's in the Woodland Hills area. What's going on is that Commission approved the case, which involved a zone change, conditional use for alcohol and a number of things. Also approved a specific plan exception and project permit compliance. So what I'm here today is I'm recommending approval of item number 12A, which is what the Commission approved back in their determination date of September 30th. And for 12B, which is the appeal of this case, and the appeal is for its questioning the issue of noise mitigation as addressed by one of the conditions of approval. Basically, condition number 14 requires a noise study, and this, I believe, would address what the appellant is citing. There's also a condition number 22, which requires a sound wall between an alley and the single-family residential areas. So this wall basically is looked at as the only alternative to lessening the noise and addressing the mitigation here. What I'm requiring under that condition number 14 is to require also some alternative mitigation measures for this as well, if the wall does not materialize. The wall, incidentally, can only be built if 75% of the owners of property in the residential area agree to this sound wall. This is a condition of the volunteer condition, of the applicant for which the Commission approved. So this is sort of the dilemma that the neighboring property owner or the appellant is concerned with. And if the wall doesn't materialize, we have to have some sort of alternative.
So the bottom line is that we don't have consensus by the property owners on how to deal with the sound.
Precisely.
And so what you're offering to us, the sound wall is a priority if the neighbors agree. And if they don't, you are proposing other physical features that will hopefully address and mitigate the sound?
That is correct. Now, these features, as you probably can imagine, could include acoustic paneling on exterior walls of the market. It could include planting and other types of materials. So I think there are other alternatives out there, but we've yet to see them come out in this sound study that's been required. So my feeling is that I think we can have the study address the alternative sound mitigation, and it would be appropriate in this case. So if the committee decides to approve the appeal in part, I would recommend that we hold on to all the conditioning as approved by the Planning Commission. And I've submitted a little package which includes some typographical fixes and clarification fixes that are pretty minor. So the committee could potentially include some sort of language relating to an alternative. But
well, let's hear from the appellants first, and from the stakeholders, and then if we have more questions, we'll ask you to come on back.
Okay, and I reserve comment on the applicant's submittal. So there's one thing I probably want to comment on there.
Okay. So let's hear from the appellants. Who are the appellants on this case?
That would be Mr. Parvez Kohanchi.
Correct.
Yeah.
And Mahnoz Kohanchi. We have a.
I have copies of my.
Okay, can you give us your name and address one more time?
Okay, I wrote it. Do you want it? Do you want a copy of my speech, or I just read it for you?
You could submit your speech, and also I want to make sure you're given the time needed to make your statement. So I want to know why you're appealing.
Good afternoon.
Good
Thank
afternoon.
you for hearing me out. We're residents. Let me just read this. Our family has lived in this house.
Can you speak into the microphone?
My name is Mona Kohanchi, and we live right across from the proposed pavilion site, across the alley. Our family has lived in this house over 13 years now. This house happens to be right across the alley where the proposed loading dock is supposed to go. When we purchased this property, we never in our wildest dreams thought that the supermarket this size would be opening right behind our home. And we had never heard or seen one built across such a narrow alleyway. We are not talking about a street, it's a 15-foot wide alley. Our concern is the significant amount and level of noise that is going to be created on a daily basis behind our fence. We recently replaced our pool equipment and filtration system, and we had to get a noise permit. An inspector came over, measured the amount of noise created by this new piece of equipment. This was just to make sure we would not be producing noise above significant levels that would be heard by our closest neighbor. We hope this standard is also applied to the pavilions and all the noise that they will be producing behind our backyard. The preliminary noise study prepared by the pavilions people has concluded that a barrier wall is needed to reduce the noise to under significant levels. In fact, this wall has to be built in order for the noise inspection to get a passing grade. Pavilions has volunteered to build a 9-foot sound wall all across the alley as a means of noise mitigation. The city planning also recommended this wall to go up if 75% of the residents across the alley are willing to give up their rights to the said alley. This all sounds good, but what if the residents consenting to the building of this wall are not at 75% level? Our concern is a legitimate one. There needs to be a foolproof way to reduce the noise of the 20 or so delivery trucks stopping, backing into the loading dock, trash collections, air conditionings, and many other related noises produced by a business of this size on a daily basis. The reduction of noise has to be done right at the property line level. Let's not forget, this is a business that is going to be there for a long time. It's not a temporary situation. Our pool equipment noise level was measured right at the border of our yard with our neighbors. If we hold this standard to this awesome business, then noise level should be less than significant right at the property line. If that would be the case, then double pane windows would really be only considered for our indoors. Just so you know, we already have double pane windows, and we have also planted over 60 Italian cypress trees right at the border of our property. But we still wake up every day with the noise of the trash truck at 6:30 picking up the neighboring businesses to the pavilion site. And by the way, in these meetings, we have learned that they shouldn't even be there at 6:30. They should be there after 7 a.m. The point of all this is that we have lived there for almost 14 years. Trucks have been there, and it hasn't been so bad. But this pavilion's plans, we are not so sure. It will be more of the same. But to reiterate, the preliminary noise study shows that the noise level is at a significant level. Pavilions has to come up with another plan to reduce the noise level if the wall does not materialize. There needs to be a foolproof way to reduce the noise to the neighboring residents if the barrier wall does not go up. 75% of the residents have to approve for this wall to be built. I have spoken to my neighbors. We don't have 75%. The plans for pavilions should just stop until such time this issue is resolved and all are satisfied. By the way, we just remodeled our home, and as luck would have it, our home has lost a lot of its value due to the economy. And if Pavilion does not come up with a solid plan to mitigate the noise, our home is going to lose even more of its value. And this is our only nest egg, and the consequences could devastate our lives. I have spoken, the people for Pavilions and Mr. Kwan have been really more than friendly, and they've been really nice to talk to us about the stuff. We've come up with little suggestions here and there, like how can we reduce that percentage so that we can get the wall,
Okay.
or maybe have some gates in the wall.
Okay. Well, let's conclude with we'll hear more from the other speakers, but I want to thank you for making the trip here, and thank you for your presentation. Okay. Anyone else here speaking on behalf or with the appellants?
Mr. Dolgen had to leave, but he was here. He filled out a card, but he had to leave.
Okay. So we have left on the speaker cards Mr. Gary Ross. Are you here? Then we have Fred Gaines, and then we'll have Mr. Brand, who's representing the council office. So Gary Ross or Fred Gaines, and/or?
Hi, good day. Thank you, Chairman Reyes and committee members. My name is Gary Ross. I'm one of the owners of the adjoining property, part of Corbin Village. We've owned the property since 1972, so I'm one of the owners and a managing partner. This property has been in existence since 1955, and it has been in a divided ownership since approximately 1958. So
divided, you said?
Divided. It's a very unusual property, in as much as the developer and the money people divided in 1958. So we came into possession in 1972. There have been 2 or 3 owners at any given time. And it's been quite a struggle. And Woodland Hills begins at this particular street at Corbin. So we are the gateway property. We are the threshold of Woodland Hills. The first thing you see is probably one of the most blighted properties in all of Woodland Hills. We have struggled with our co-landlords to try to get the property improved, to do the right thing with the community and the neighborhood. We have a very upscale community surrounding us, and to no avail. We have put untold millions into upgrading our side of the property, trying to embarrass them into working, and thank God, 5 years ago, Vaughn's Safeway Corp, under Vaughn's Pavilion, came along and purchased the other 2 owners out and became our co-landlord. And we applaud them, and we are supporting them 100%. To that degree, we have, our goal is, if they should prevail in this project, and we trust they will, we want to create a uniform project from Oakdale all the way to Corbin, so the front of our buildings.
I appreciate the history and the complexity of the situation, but given the appellant's concerns with noise, what's your response to that?
My response to that is, if you lived there 13 years and you have 25 stores or more behind you, even more than that, that you've had so many types of delivery trucks, and to this day you have 99-cent store at one end of the center, and you're having truck delivery. You have 20-foot pups, even 40-foot pups with diesel unloading on the alley out with forklifts.
I understand. I appreciate what you're saying,
Plenty
but
of
here you have a
noise.
new development. It should be getting the neighborhood better. I mean, you should have a more
Absolutely will
positive impact,
improve
and
the
noise is one of them.
Sorry, pardon me.
And noise is an impact. So are you saying we can't build that wall? We can't get to 75%?
I don't know why they can't. Why won't the neighbors agree?
Okay.
It's their issue. Vaughn's has agreed to build it.
You're a neighbor too.
Vaughn's has agreed to build it.
But you're a neighbor as well.
I'm a neighbor as well. Absolutely.
So let's get to the 75. It would really help.
I don't know why they won't agree.
Okay, so thank you.
I think it would
Is that
certainly improve their property and enhance the community
Okay.
and improve their property values.
Okay.
Thank you
sir.
for your time.
Thank you. Mr. Gaines.
Thank you, Mr. Chairman, honorable members. Fred Gaines of Gaines and Stacy on behalf of Vaughn's Pavilions. We have worked for now a few years putting this project together, worked diligently with the council office, with neighborhood groups, with the immediate neighbors, several community meetings. You have attached the letter that I submitted to you today, letters of support from the Woodland Hills Warner Center Neighborhood Council, from the Woodland Hills Tarzana Chamber of Commerce, and also from the Forest Hills Homeowner Association, which is the voluntary homeowner association from the area.
So that means, Mr. Gaines, you'll get to 75%?
Excuse me?
Does that mean you'll get to 75% with all that support?
We fully expect that we will. But let me just go through. You need to. I'd like it to have 2 minutes so you can understand this in context.
Okay.
This is a shopping center. I've given you a little brochure of photos and so forth dating back to 1956. It was a thrifty market built first, the alley and the homes behind it. And it's, so for 50 years we've had the shopping center adjacent to the alley. In addition, as you know, the city has rules about what you do when you have these kinds of boundaries and where the residents come up, and that's why we have our commercial corner ordinance. We haven't asked for a single exception from commercial corner ordinance, and that regulates what we can do in terms of deliveries hours specifically for this. You know, so you can only go 7 a.m. to 8 p.m. on the weekend, shorter hours. We haven't asked for a single additional hour. By the way, the market would rather have the trucks come at night. Okay. Your transportation energy policies, you'd rather have our trucks come at night. But we're not going to do that because we have noise in the alley. We're going to come during these daytime hours, peak traffic hours, and we're not asking for any exception whatsoever. We did do a sound study that talked about all of our equipment use, found no sound meets all the requirements. It talked about deliveries. What we're talking about now is a trash pickup situation where, one, we've agreed to do it within the hours that are contained, and two, we've agreed one per day, one trash pickup a day. So we're talking about a very short period of time where in the alley you will have a trash pickup. We are building, in this case, a fully enclosed loading dock. So think about your local supermarket. Does it have an enclosed loading dock or an open loading dock? Probably has an open loading dock, but we're going to do an enclosed loading dock. Now, finally, what we did, and this is sort of the no good deed goes unpunished rule, is we had meetings where people said they'd like the sound wall. So we looked into it. We actually designed the sound wall, and everyone said they wanted it. We never thought we'd have a problem with, once we said, fine, we'll build the sound wall, people then showing up at the Planning Commission saying, well, I'm not sure I want the sound wall. And that is why Commission President Usher said, well, let's make it 75%. If you can get 75%, we're ready, willing, and able to build this sound wall. We expect that we will build it. It does potentially require an over in height fence requirement, which we've agreed that we'll go through that process and get it, but we've crafted conditions that allow this to go forward. So there's two important things here. One is the hearing examiner and the planning commission have included a condition where we will do a supplemental sound study to look at all possible alternatives, and we have no problem with that condition. In the letter that I've submitted to you on page 4 is some language where we've tried to clarify this. The very first change that we submitted, that the issuance be on final certificate of occupancy, we agree that we are no longer asking for that. It'll be on the exact language that was submitted by the zoning administrator by the hearing examiner and the planning commission, that it be before any building permit is issued. The other changes we do ask for, and what those changes do is actually add more flexibility. It says we'll do the sound wall or other off-site mitigations. So if we do this additional sound study, it says that there's other mitigations that we'll do. We'll do those instead. It opens that up, and we added that specifically to deal with this one appellant's concern that what if you can't do the sound wall? Are there other things you can do? So we're now going to do an additional sound study. The hearing examiner is going to determine what the appropriate conditions are. If enough people want the sound wall, we'll build it. If that for some reason is not the correct mitigation and there's other mitigations, we're willing to do those as well.
So today's action triggers a process where you have that discussion before construction?
Excuse me?
Before construction, what you're presenting to us right now?
We will have to do a revised sound study before any building permit is issued. That will, noise study before any building permit is issued. That'll go through alternatives to the sound wall in the instance that the sound wall is not built.
So this action today can still trigger that possibility, or it will require it?
It will require the additional study,
okay,
and the imposition of additional mitigations by the hearing officer, okay, if they determine based on that study that those are warranted. Now, the action we're asking you for is to approve the zone change, approve the other approvals, so that we can go forward with this, move forward with the project. We won't get a building permit until we've conducted this additional sound study, looked at other alterations, and we will move forward to seek approval of the sound wall and build the sound wall if we receive the requisite approval.
And the appellants will be part of that discussion?
Absolutely.
Okay.
And so we believe that with the two changes in the language, which actually broaden it to allow us to do the sound wall or other mitigations, with the condition that has been imposed by the hearing officer and by the unanimous vote of the planning commission to include this. We think this is a good project. We really would appreciate your approval.
Thank you.
Thank you.
All right. And Mr. Brand from the council office.
Good afternoon, Chairman Reyes, council members. I'm Jonathan Brand with Councilman Dennis Zines' office. This is one of the western half of this shopping center is one of the most blighted properties, not just in Woodland Hills, but I feel all along the Ventura corridor. And this project will make the neighborhood better. I know the number one issue is the noise mitigations. Right now, the property is not subject to the commercial corridor ordinance. This project will make it be in accordance to it. It will bring the 99-cent store up to the standards of the commercial corner. It will have the trash located in a different enclosed area. We do have the enclosed loading dock that they mentioned. We are in agreement with the planning department and the CPC recommendations here. There are a lot of things about this project that will make the neighborhood much nicer, you know.
Right. You don't have to convince me on the merits of the project. Can you commit to me that you will inform the appellants about the mitigation so that we can address their needs, being that they live right next door to this property?
Absolutely.
We have that commitment from you?
Yes, sir.
Okay.
We've been doing that all along the process, and we'll continue to do so.
Okay, so we want to make sure that everything is done to make sure we don't behave in a punitive manner given their quality of life issues with the ingress-egress and the backside of that structure, correct?
Yes, sir. And the major concern of this council, of our council office, is to make sure that the noise associated with this project can be completely mitigated and not decrease their quality of life.
Okay. Okay, any questions, my colleagues? Okay, Frank, did you have any comments? You said you had a letter you needed to review?
Right. Mr. Chairman, I think Mr. Gaines already explained
Okay.
the correct recommendation I would make in that case on his letter as far as the language, and I would be more than happy to provide the clerk that information and make sure it's straightened out. As well as what corrections Mr. Gaines is proposing, I just wanted to make sure that you included my recommended slight corrections and typo things that are house cleaning issues, really. And
are you comfortable with the direction that we're taking in terms of given all the information you have? Have you presented everything we needed to know for this case?
I believe we have it all in paper today.
Okay.
Yes.
Well, I'd like to perhaps move to deny the appeal with the understanding that there will be a commitment to address the issues of noise, and that you have the language submitted by Mr. Gaines in terms of finding a way to mitigate that impact. Do we have a second on that?
That'd be great.
So
Thank
that'll
you.
be unanimous, all thumbs up. Okay, that'll be the Actions Committee to deny the appeal. And you do have a commitment from the deputy to work with you on the impacts of the noise, and I can move forward on that. Anything else, Roberto, for today?
No, Councilman, just public comment.
Okay, anybody here for public comment? We do have one card. It's Mr. John Carpenter. Welcome, Mr. Carpenter.
Good afternoon. Can you hear me okay? Or
Yes, we thank you for your patience. You waited till the end of the meeting, so thank you.
Thanks. A new apartment complex was built in District 1 on 2nd Street as part of the land use program, which required them to set aside 20% for affordable housing. Before that complex was even started, I contacted the owner of the building to get my name on the list. The building was completed, and I gave him my Section 8 moving voucher for a 3-bedroom unit, which they had, but they said that 3-bedroom units were not put on the allocation of affordable units list. And the only way I could get that changed was to have the city council do that. So I've written a very brief and concise 1-page motion to remove 1 2-bedroom and 1 1-bedroom unit from the allocation of affordable units and substitute 1 3-bedroom unit. So the total number of bedrooms in that apartment complex will not change at all.
Okay.
And the owner will get the exact same amount of rent because they'll be moving 2 units to market rate and the 1 3-bedroom to the affordable rate.
Mr. Carpenter, can we meet after this meeting to go through that
Absolutely.
detail? And have my staff work with you, and I want to follow up on that.
Okay, thank you.
Okay, thank you, Mr. Carpenter. Okay, anyone else here for public comment? Seeing none, this meeting is adjourned. Thank you.
Yes, he approved. Yeah.